A jury has been seated in a trial to determine the will of the Queen of Soul, Aretha Franklin. Franklin died in Detroit in 2018 at the age of 78, and just months later, family members say they found two handwritten wills in couch cushions.
Yeah, Franklin's sons are arguing over which of the wills should be applied to the estate, one dated in 2010, or a second dated in 2014, which was found in the cushions of a couch. Both documents appear to indicate the sons should share the money from the music and copyrights, but they differ on who would be the executor of the estate.
Joining us now to discuss all of this and the trial is Danielle Mayoras, a state attorney with Barron Rosenberg, Mayoras and Mayoras. Thank you so much for being here tonight. We appreciate your time.
Thank you for having me.
So let's get right into this. Aretha Franklin's sons are fighting over that handwritten wills found in couch cushions. Can any of these be considered here in Michigan?
Well, they can, but actually the 2014 document is not necessarily a will. And so that's what this jury trial is about. It's a handwritten document, but there's a question if it actually is a will, because in order to be a will in Michigan, it needs to be in someone's handwriting, signed and dated by them, and they need to intend it to be a will. And there's a lot of questions around that.
So you can write a will, it doesn't have to be notarized, or just as long as it's your handwriting, your signature, it will count.
If you intend it to be a will, Michigan is one of the states that has an exception that you can actually write your own will. You don't need to work with an attorney like me, although I do recommend that, so you don't end up like Aretha Franklin.
Yeah.
How do you prove intent? And look, I don't know if I'm sure you haven't seen the actual will in question here, but how do you prove intent if I just scribble something and sign?
That's exactly what Aretha did. She scribbled something. So I actually have seen the 2014 document, and it is crazy. There's scribbles, there's blanks, there's even something that says fill in. She has things crossed out on the document. And so the intent to be a will, sometimes it's very clear because you sign and date the last page and you say, I intend this to be my will. And actually on the 2014 document, she did say at the beginning that she was writing a will. So we'll see what happens in the jury trial.
I'm not saying I know this from personal experience, but back in high school, I could master my parents' handwriting pretty good. How can you possibly prove that she even wrote that?
Well, they're going to have a handwriting expert, so that is a given. We know that they'll have an expert. There is something on the last page, or almost the last page of the 2014 document, where she did sign Franklin, and it's a smiley face, but it's not her full signature. It's not her full name.
So you have seen these documents, at least the 2014. How do you see this playing out with your expertise? Where do you see this going here? It's obviously an awful situation the family's dealing with since she has died 5 years later. Where do you see this going?
I think it's a roll of the dice, and anytime someone goes to court, like a family like the Franklins, that's what happens. The issue with the 2014 document is, even though it's in her handwriting and she seems to say at the beginning it's a will, it seems like it maybe is a draft because there's blanks, as I said, things crossed off, and it's really unclear. Did she intend this to be a will? And if she did, why is it on a spiral notebook stuffed in some, couch cushions? Why didn't she actually tell somebody about it or put it in a locked drawer like she did the 2010 will?
Right, and with them already having decided that the money for the most part will be split, what are they going to argue in court? What does being the executor really mean for either one of them?
That's a great question. It's not just about being the executor. One of the big issues is her home in Bloomfield Hills, the Turtle Pond home. That was valued over $1 million at the time that she passed away. And the difference between the 2010 document and the 2014 is who receives that home. So there's a big fight over that. That's a big portion of the estate. Obviously not the biggest portion considering what she can bring in the years to come, what her estate will receive.
Okay.
Is it kind of shocking that somebody as famous as Aretha Franklin did not have her affairs in order here, and it's left up to her kids years later still fighting over her estate?
It's surprising in some ways, but not in others, because 2/3 of Americans don't even have a simple will. You would think that given her notoriety and all of the intellectual property she has it, she would have done that. And in 2018, there was a document drafted by a law firm, but she never signed it. So a lot of celebrities and other individuals unfortunately have a distrust of attorneys. Maybe she couldn't make up her mind like so many people and they're just trying to get it just right. Who knows?
So at the end of the day, does this really all come down to money, do you think?
I think in this case, that's what it's coming down to. It's coming down to money and control over the estate. Who's going to control it as the executor?
Yeah. Wow,
right.
Danielle, thank you so much for
Thank
joining
you.
us. That's some confusing stuff. Thank you so much.